At precisely 10 miles this morning, a defensive shield that had protected the former president for over 4 decades didn't merely crack, it crumbled entirely during what was meant to be a routine sworn deposition. Eric Trump was confronted with a line of questioning crafted with precision, designed to function as an inescapable legal trap. For months, the defense had relied on a single repeated strategy, the phrase, "I do not recall." It's a tactic heard in countless depositions, analyzed in high-profile cases, and considered the cornerstone of white-collar defense, a concrete wall intended to shield those at the top of corporate hierarchies from direct accountability. Yet today, under the unrelenting weight of a perjury warning, that wall turned to dust. I have the full transcript of what transpired immediately after. Before you dismiss this as just another sensational headline or routine legal theater, recognize the gravity of the stakes. This wasn't a campaign speech or a staged press conference. It was sworn testimony under penalty of perjury. The admission I am about to dissect a bleeder. It's the primary defense narrative that the former president has leaned on to safeguard his business empire from potential collapse. The defense has long claimed he was a high-level visionary, preoccupied with running a country rather than reviewing the minute calculations behind asset valuations. They argue he depended entirely on outside accountants and entrusted his sons with operational details. But today's testimony demonstrates, with devastating clarity, that the chain of command extended beyond the sons. It reached the very top. I will highlight the exact moment plausible deniability was extinguished, reading the precise words Eric Trump spoke. The statement is one prosecutors will likely project before a jury as the central piece of evidence, transforming a civil fraud case into a complex legal nightmare. It all began with a single, surgically precise question, forcing Eric into a binary choice: protect his father and risk committing a felony, or protect himself by revealing the truth. He opted for self-preservation. For those seeking immediate intelligence before mainstream coverage catches up, I've set up a private WhatsApp channel in the description. Here, I post unfiltered updates and document analysis that often don't make it into the final edit due to time limits. This is strictly informational, no spam, just insight. To understand why this admission is catastrophic for the defense, consider how perjury traps are constructed. This isn't about a simple gotcha question asked in the first minutes. It's an architectural process. Prosecutors methodically compel a witness to commit to a specific narrative, locking them in and slowly sealing the exits. For weeks, the defense team built an insulation layer. The narrative portrayed the former president as a visionary creator, a big-picture architect busy to scrutinize spreadsheets or double-check property valuations. Delegates handled the details, meaning any fraudulent numbers were supposedly beyond his knowledge. A textbook white-collar defense aimed at shifting blame to accountants or middle managers. The sons were crucial to this plan. Eric was supposed to act as the firewall. If he testified that decisions were made independently or only in consultation with accountants, the father remained insulated. But prosecutors were aware of this. The line of questioning was meticulously directed at authority. Who had the final say? Who signed checks? Whose approval was needed for golf course valuations? They weren't immediately hunting for fraud admissions. They were searching for evidence that the sons reported every detail to their father. If so, his knowledge would render the insulation meaningless. High-stakes depositions create intense psychological pressure. The witness understands the family's expectations to maintain the corporate shield, but is also where the prosecutor has emails, memos, and logs. Lie, and you commit perjury. Tell the truth, and you expose the boss. Most witnesses attempt gray area evasions. Phrases like, "I don't recall that meeting," or standard procedure, but today the questioning left no room for ambiguity. A specific document was produced, and a question was asked that demanded clarity. That was the moment the defense strategy fell apart. Listen carefully to the exchange from the sworn record. The prosecutor asked, "Did you verify the accuracy of the statement of financial condition before it was signed?" This is a perilous question. Answering no admits gross negligence. Answering yes confirms knowledge of fraudulent numbers. Eric initially deflected, claiming, "Size, I relied on the accounting team. We have great professionals." But the prosecutor presented a document showing Eric's signature on asset certifications. Then came the pivotal question: "You signed this. Did you have the authority to approve these valuations?" The explosive answer that sent the defense into chaos. I verified everything with my father. He knew every deal. Repeat that sentence. In court, those words are decisive. Up to this point, the former president maintained he was detached, preoccupied with presidential duties, delegating details to his children and CFO. Eric's testimony under oath now confirms direct, active involvement by his father in reviewing and approving deals. Verified implies scrutiny, review, and consent. Everything is comprehensive and not just flagship properties, but the full range of operations. This obliterates the defense central claim of ignorance. The courtroom reaction is predictable. Silence, shock, frozen lawsuits that cannot be retracted. A juror would weigh the father claiming ignorance against a son testifying he verified all deals. The logical choice is the son, who has no motive to lie about his own role. In attempting to justify his own signature, Eric shifted the responsibility onto his father, exposing him legally and morally, a textbook example of piercing the corporate veil from within. Social media erupted almost instantly, filled with rage, personal attacks, and claims of a witch hunt. Look beyond the surface. This is fear. When a defendant lashes out during legal proceedings, it reflects loss of narrative control. The panic stems from a legal reality known as imputed knowledge. Eric's admission created an unbreakable line of liability. Civil fraud requires proving the boss knew of and did nothing to stop wrongdoing. This testimony allows prosecutors to connect undervalued assets directly to the former president. The flurry of legal motions delays attempts to strike testimony as mere damage control. The transcript is permanent, etched into the record. Picture the war room, lawyers informing the former president that his son's testimony likely forces him to testify, walking into a perjury trap of his own. To protect himself, he must declare his son a liar, an impossible paradox of family and law. The explosive reaction stems from the collapse of the loyalty circle, reminiscent of organized crime prosecutions. One lieutenant's disclose the boss awareness, the case escalates to top leadership. Was this slip accidental, or a calculated move to avoid felony liability? History offers insight. Reviewing Trump University and Trump Foundation cases shows a consistent pattern. Family loyalty is used as a shield. Family members in key positions are trusted to adhere to the script. Yet, under intense legal pressure, loyalty can fracture against self-preservation. In the Trump Foundation, children on the board can protect the patriarch without risking personal liability, resulting in fines and dissolution. The same dynamic is now unfolding on a much larger scale, threatening the entire business empire. The Rome manager defense works only until a key figure must choose between conviction and truth. In prior cases, sons and family-run businesses held the line until presented with sentencing guidelines, at which point memories of verifying everything with the father returned vividly. The human element of the law of oath clarifies memory in ways nothing else can. Eric Trump, experienced in depositions and pleading the fifth, answered this question in a manner signaling pressure breaking through training. This suggests his legal team may have diverging advice from his father's attorneys, a dynamic that destabilizes conspiracies when defendants act in self-interest. This sentence alone carries immense consequences. Civil fraud trials involve hundreds of millions in penalties and risk of business license revocation. But the danger extends beyond civil court. Evidence travels between jurisdictions. Federal prosecutors investigating bank fraud can use this transcript. Bank fraud hinges on intent. The "I didn't know" defense negates intent. Eric's testimony closes the gap if his father verified inflated numbers. Criminal intent is established. A domino effect follows. Civil defense collapses. Licenses are jeopardized. Internal records exposed, guiding criminal investigations. Immediate consequences are severe. The presiding judge now has sworn evidence connecting the top leadership to fraud, with authority to appoint monitors, freeze accounts, or mandate asset sales. This is no longer a rogue team. This is a top-down scheme, punished harshly under the law. Accountability cannot be delegated. Decades of the Trump Organization operating under the belief that layers of management shielded the signature line are now exposed. Law is designed to identify the true holder of power. Eric's testimony drew a direct line from fraudulent statements to the former president's desk. External reaction, social media outrage, attacks on judges, and press cannot alter the record. "I verified everything with my father" is indelible, central to opening statements, closing arguments, and final rulings. It is the primary reason the defense strategy collapsed. The legal system works when oaths compel truth. It's messy, slow, and complex, but facts prevail. Evidence is mounting. Subscribe to stay updated on filings because Eric's admission triggered immediate, devastating consequences. Fraud is punished irrespective of financial gain. Lying on a loan application undermines the marketplace. Eric's statement confirms intentional manipulation of numbers for profit. The judge recognizes that corporate integrity depends on accurate financial statements. The repercussions could be severe, sending a message that no one is above the rules of arithmetic and honesty. Watch for the reactions of other family members who now face the same dilemma: uphold the narrative or protect themselves. Courtroom psychology, it's contagious. Once the truth emerges, it gains momentum. Eric's admission has paved the way for a cascade of further confessions, potentially rewriting the history of the Trump Organization. Consider the legacy aspect. An empire built on a myth of success is now exposed, revealing inflated assets, falsified records, and a reliance on deception to maintain the illusion of wealth. Eric's testimony did more than highlight legal liability, it exposed operational reality. The father validated the fraud. This is a turning point. Speculation is over. The events are unfolding in real time, documented in sworn transcripts. The shield is gone, insulation removed, and the former president stands exposed by his own son. The legal machinery is moving with purpose. Prosecutors have their evidence, the judge has the record, and the defense strategy is irreparably broken. The coming weeks will determine the fate of an empire built over 40 years, now jeopardized in seconds by the truth. Stay tuned. Filings are arriving rapidly, and the stakes continue to escalate.